vegetation rights has been granted on 18/7/2024.
18/7/2024.
24.
You're for the father or the mother?
I am mother, my lord.
You're for the mother.
Mother.
What is the order? Let's go to that operative portion.
The operative portion, my lord. Before operative portion, the marriage inquiry number 38, my lord.
Just see it, then you can submit.
My lord.
Let me just look at it, then you can submit the facts.
Yeah.
Let's look at the operative portion. What did the court do?
Yeah, please.
Defendant is hereby directed to keep present the child between 11
Vegetation
AM
rights
to-
have been conferred, given, my lord, on first and third Saturdays between 1 to 11 to 2 p.m., my lord. To the respondent herein, husband, my lord. The crux of the
What
point,
is the age of the boy?
it is a minor daughter, my lord, about 4 years.
4 years girl.
4-year girl, my lord.
When is the marriage?
Marriage 11/11/2018.
When the daughter born?
2020, my lord. That is
And from how long they are separated?
from 27/6/2021.
Hmm.
When the baby was 10 months old, my lord.
Huh?
When the baby was 10 months old, my lord.
Hmm.
From that day to this date, the respondent herein has not made any attempt not to know the name of the child.
But
nor-
this appears to be a suit of 2021.
My lord.
This appears to be a suit of 2021.
Yes, by the respondent, my lord.
That's what I'm saying.
Yeah,
You are saying that he has not taken any steps, but he has filed this application.
yeah. But in spite of that, in spite of application is filed, he has not conducted gone with the matter from time to time. In spite of the matter was listed for evidence, cross-examination, or one or other way.
Now, what is the urgency for what this memo
Yeah.
is moved?
The reason I may straight away taken to my lordship by annexure R, page 124, which was filed prior to one and a half years for filing of the suit, my lord. Vegetation rights, my lord, for filing an application.
124 is FIR.
Yes, the FIR is the contentions are in the inquiry number 126. It is in Kannada
Filed by whom?
by the mother
Stating
against the father, my lord,
Stating that.
stating that they have made an attempt to disturb the child, kidnap the child, and to make harm to the child, and they have mentioned, categorically mentioned, that the child, even if the disturbance is caused to the child, it is going to affect the interest of the mother. Thus, there is a great threat to the security and safety of the child by the petitioner, by the respondent here, my lord. As a result, without looking into this consideration, the trial court, family court, was pleased to allow the visiting rights, my
I
lord.
remember some grave urgency, some health issues were projected before the court.
Because the urgency is, my lord, if he is permitted to visit the child, there is every likelihood of poisoning the minds of the child, my lord.
That we can't help it.
The child will not identify the father, my lord.
Let him identify. He should identify who is his father. And he should know. Those are not the grounds.
No, because he has made all efforts all this litigation started because of properties and monies, my lord.
Like now we are only
it is
concerned
only-
with what is wrong with the order. And the reason what you say is that she gave a complaint, that cannot be a reason. The father has every right to see the child. If something is not right, something is not going right, please tell the trial court that it is not happening. First of all, they have to meet. First, let him meet. Once he meets, if something is not going, you can tell the court that please modify the order. It's not going well with the child. But you cannot come to the High Court on this reason.
No, because it is not only one FIR, my lord. There are
When there are
FIR.
when there are disputes between the wife and husband, they will file 100 FIRs. Those are not the reasons for the court not to grant visitation to the child. That too, where did the court grant? In the mediation center. That too for a very, very short time. Even that also, if the mother do not want to complain and come up with all this.
The whole difficulty is the mother, the only care taken by the mother. Custody, it is in the custody of the mother, and she is taken the care of the child. And if it is disturbed, how
it is disturbing? How they are disturbing that? How it is disturbed? Why what she wants forever? She will not let the husband see the child. Is it fair on her part?
No, let my endeavor is if the ad interim order of stay is granted, and in my endeavor, kindly appreciate this. I'm for a moment what is running in my mind, that is I'm expressing before your lordship. Even if the opportunity of notice and stay is granted, then at least a sort of iota of efforts will be going to be effected by the respondent, father, my lord. Under these circumstances, my endeavor is just to, for a limited period.
No. No reasons to stay this order. Please come. Agreed with orders passed in I number 6 and OS number 345 of 2021, dated 18/7/2024. The mother is before this court. The I number 6 is filed by the husband, by the father, seeking visitation rights of his minor daughter. In that, the court had passed an order directing the defendant to keep present the child between 11 a.m. to 2 p.m. on every first and third Saturday, twice in a month, in the visitation room, Nyaya, the law building, 4th floor, allowing the father and his mother spending valuable time with their daughter and granddaughter, and directed the father to pay the expenses incurred to the wife to keep present the daughter in the visitation room. Learned counsel agreed thereby the mother is before this court. Learned counsel appearing for the mother submits that in fact, when the girl is 10 years old, and you have the differences, the parties are residing separately. It is also submitted that the father had never taken care of the child till now. The child can't even recognize the father. And the mother is the sole caretaker of the child. If now the father is permitted to meet the child, he may poison the mind of the child. And it is submitted that earlier, the wife had given a police complaint stating that the father is trying to kidnap the child, and there are several other complaints of that nature. It is submitted that it's not in the interest of the child to meet the father. It's not in the interest of the child as well as the mother to meet the father. Next, having heard the counsel for the petitioner, this court had perused the order passed by the court. The court had granted the visitation only on the first and third Saturday in the visitation room. The apprehensions that are placed before the court by the learned counsel for the petitioner are not the reasons to be considered, or this court finds no reason to interfere with the order passed by the trial court. While if pursuant to the order passed by the court, if while exercising the visitation, if any untoward incident takes place, or the boy is comfortable, the girl is not comfortable, or something else has happened, then the cause of action would arise for them to submit to the court what has transpired. Basing on that, the court will pass further orders. But on the submissions of the counsel and with the apprehensions the wife has are not the reasons for this court to interfere with the order in that view of the matter.